2022 Browning Symposium. I'm Elaine Gagliardi, the interim dean of the law school, and we are delighted that you have joined us for a discussion of Montana's Constitution, the next 50 years. As we begin the second day of the Browning Symposium, I want to again read the law school's land acknowledgement. This law school is on the traditional lands of indigenous peoples, including the Salish, Sanka, and Klesky. Many others, including Blackfeet, Nez Perce, Shoshone, Bannock, and the Coeur d'Alene, had and continue to have a crucial presence in the area. We acknowledge the role the legal system has played in the removal of indigenous peoples from these lands, and through our commitment to education, service, and scholarship, strive to improve the quality of justice for future generations. Doing so demands respect for tribal sovereignty and indigenous cultures, as well as accountability to the needs and perspectives of indigenous peoples, who from time immemorial to the present and until the end of time protect and remain connected with this land on which we gather, live, learn, and work. This symposium is named for the Honorable James R. Browning, who was the longest-serving Chief Judge of the United States Court of Appeals for the Ninth Circuit. I was fortunate to begin my legal career as his law clerk at a time when he was chief. Some of you heard my tribute to Judge Browning last evening, and for those of you who did, please indulge me. The law review asked me to provide it again for those of you who were not with us last evening. 3 words best describe Judge Browning: leader, communicator, and innovator. The Ninth Circuit doubled in size under his leadership, and he instituted the first computerized docketing system in a federal court. As a University of Montana law student, he was no different. Judge Browning was one of the founding members of the Montana Law Review and ultimately served as its editor-in-chief. As his law clerk, I learned many things from the judge. He taught me the importance of a positive attitude. Judge Browning believed he could accomplish whatever he set out to do, and he did. He taught me the importance of a smile. The judge always had a ready smile. For those of you who knew him, it was a gorgeous smile, and just put everyone at ease in his presence. And to him, that was the essence of being a Montanan. Of the importance of communicating and listening. He reached out to get the opinions of all around him when making decisions impacting court administration. And most importantly, of being fair, and he would always remind his clerks to put aside any of our personal biases. Justice Kennedy recalled of the judge, his smile was the smile of one who was immensely proud to dedicate his life to public service and to being a fair-minded man and a mentor to all with whom he served. Judge Browning would be proud to see his legacy continue. I want to thank the editors-in-chief of the Law Review, Ben McKee and Eric Monroe, and the symposium editors, Blake Comins and Lauren O'Neill, and the dedicated editorial board and staff of the Montana Law Review for bringing together such an outstanding group of speakers. This morning, I would also like to take some time to thank all of you in the room and those of you who are joining us by Zoom. I know there are many of you who gave your support to the Browning Symposium. We are very grateful for that support. I want to especially thank the following sponsors. Our platinum sponsor is Morrison, Sherwood, Wilson, and Diola, and thank you so much for your generous gift. Gold sponsors include the Hagestad Law Group, Moulton Bellingham, and University of Montana Provost's Office. I want to thank also the silver sponsors, Williams Law Firm, Crowley Fleck, Bob and Cindy Carlson, Hall Booth Smith, and our supporters, Lewin Law Offices, Farr Holden Attorneys at Law, Garlington Lawn and Robinson, and Boone Carlberg. We very much appreciate the support you have given the Law Review and the University of Montana Blewett School of Law. And at this time, I will pass the podium to Marty Lepke.
Thank you, Dean Gagliardi. Good morning, and welcome to the Montana Law Review's 2022 Browning Symposium. Thank you for being here. My name is Marty Lepke. I'm the online editor for the Law Review, and I'm here to introduce our keynote speaker. We are honored to have the Chief Judge of the United States Court of Appeals for the Sixth Circuit, the Honorable Jeffery Sutton. Chief Judge Sutton was nominated to the court by President George W. Bush and confirmed by the United States Senate in April 2003. He earned his law degree from the Ohio State University College of Law in 1990 and subsequently clerked for the Honorable Thomas Meskel of the United States Court of Appeals for the Second Circuit, as well as two Supreme Court justices, the Honorable Louis F. Powell Jr. and the Honorable Antonin Scalia. Judge Sutton assumed the position of Chief Judge of the United States Court of Appeals for the Sixth Circuit on Saturday, May 1st, 2021. Chief Judge Sutton is one of our nation's leading experts in state constitutional law and has authored several leading texts on the subject, including 51 Imperfect Solutions, State Constitutional Law, The Modern Experience, and most recently, Who Decides? States as Laboratories of Constitutional Experimentation. Perhaps most importantly, Chief Judge Sutton is no stranger to the Montana Law Review. In 2018, Chief Judge Sutton delivered the Browning Distinguished Lecture in Law. Please join me in welcoming Chief Judge Sutton back to the Blewett School of Law and enjoy the rest of our symposium. Thank you.
All good. Please interrupt me if there's a challenge there, but I'm foolishly in a hotel room in San Francisco, having spurned your very kind offer to be in Missoula. I really don't have a great explanation except that I agreed to meet with the State Solicitor Generals here in San Francisco. I will say, actually, like this reality that I am in San Francisco, which is where Chief Judge Browning spent a lot of his time. In fact, now that I know that the Dean clerked for him, she might be interested to know that I bed to his old chambers, which is currently occupied by Judge Dan Bress, and my oldest son, Nathaniel, clerked for him the past year, so I spent some time in the former Chief Judge Browning chambers. I will tell you that I have a lovely fireplace, very high ceilings, an awful lot of space, particularly for very expensive San Francisco. My son was not able to find a way to live in his chambers, but there was certainly enough space there, and it became a lot cheaper. I'm so thrilled to be with you all. Often, when you write a book, you learn who your friends are. You write a second book, you really learn who your friends are. So thank you so much, and I'm really sorry I can't be with you in Missoula. I think I'll talk for about roughly 30 minutes or so, and I hope that leaves time for some questions. I really enjoy being challenged and hearing how people respond to what I'm saying. I'm basically going to pick up on some themes from the book that seem to apply to what's going on in the country with respect to American constitutional law, judicial review, and this sort. I had one overarching point, which I think is very consistent with the theme of this Browning Symposium. It's in America, it's so tricky trying to figure out what is national and what is local. So often, what we want to be national is what we really care for and like, and what we're willing to tolerate as local is what we don't care for. But it's not quite as simple as that between 30 million Americans with an awful lot of perspectives in a very big, diverse country. And I just think it's an American phenomenon, trying to figure out what's local, what's national, and above all, constantly recalibrating it to account for the issues of the day. So I think I have about 14 points. They're not really somewhat randomly organized. They definitely start with the judicial perspective, which, as a judge, no surprise, is one I care quite a bit about. One thing that I've found interesting in doing the work on this book is going back to the history of judicial review. I mean, this role of the courts in American society. It's really hard to find a country in world history where the courts, state and federal, play such a big role. And, we think of judicial review, the authority of a court to invalidate a statute or an executive branch order, is coming out of Marbury versus Madison. But the reality is that, had there been no John Marshall, had there never been an election of 1800, had there never been a Marbury or a Madison, we still would have had judicial review in this country. And that's because the state courts were already doing it long before 1803. And in trying to think about the right role of courts when it comes to deciding to invalidate democratically enacted laws or democratic executive branch orders, I think it's really interesting to go back to how these early courts thought about it. One thing that you see with these early decisions is they didn't have a lot of doubt about the concept of judicial review. For them, it seemed like a pretty legitimate, in fact, they thought it was their duty to engage in it. And the way they thought about it was, at the time, there was such a thing as superior and inferior laws. Of course, the English system did not have a written constitution, so there wasn't a judicial review model they could follow from England. But the English system did have a distinction between superior and inferior laws. And the way the English judges dealt with it is if there was a conflict between inferior and superior law, where the superior law would trump. And for the early American state court judges, there was a simple analogy to this inferior-superior law, and that's that constitutions, a state constitution, that was what they were focused on at the time, would have been a superior law, say, to a state statute or an executive branch order. So on the one hand, judicial review was not just legitimate, it was part of their duty as a judge to honor the superior law when there was a conflict between the two. So on the one hand, that's very pro-judicial review. On the other hand, they were very careful to try to avoid the conflict. So they did all kinds of things. When you think of the concept of constitutional avoidance, construing a statute to avoid a conflict, they did everything they could to avoid the conflict. So to me, it's a really helpful era trying to figure out the right role of judges today, either I would say state or federal. And that's that, yes, we judges do have a duty to honor the superior law, the Constitution, whether state or federal, but we shouldn't lightly say there's a conflict between the two. This leads to one other point, which is very current after, with this current U.S. Supreme Court, but think of the Bruin case, the Second Amendment right to bear arms case. That's a very historically driven decision, just as its predecessor Heller was. And this prompts the question, perhaps anxiety, of can people like me fairly figure out the original public meaning of guarantees written in 1791 with roots that may go well back before 1791. On the one hand, I'm not too persuaded by the anxiety of judges doing history. It's not because I think we're experts at it, but it's because we have many much harder things to do already. One has to resolve patent disputes, med-mal cases, very intense antitrust or securities law problems, things we have no business doing in the sense of our actually having expertise in the area. The reason we trust general state and federal judges to referee these disputes is not because we understand all the ins and outs of it, it's because we trust the adversarial process and that good lawyers either will learn information, learn what they need to know to present the case to us, bring in amici if that's necessary, and eventually we'll figure out what the decision point is, and through the adversarial process, be able to figure out who should win. And I think that's just what's going on in history disputes, that sure enough, one group of lawyers will say, here's what it meant on one side, another group will say, here's what it meant on the other side. Now, so in one sense, this doesn't trouble me, and I have to say, as intricate legal problems go, lawyers are actually pretty good at history. So much of law is history, and if you want to say backward looking, that's true of virtually every legal dispute, not every legal dispute. But I do think there's one feature of this that is important to keep in mind, and that's that judges should be humble about our capacity to figure out the meaning of something in the 18th century. And that takes you back to how judicial review was handled at the outset. I said that they tried to avoid a conflict whenever they could, and one way they avoided conflict is to say, we're going to construe the statute so there's actually not a conflict between the statute and the Constitution. Well, the thing they did on the other side of it is they wouldn't invalidate a statute unless the Constitution clearly applied, unless there was a clear rule that came out of the Constitution's text and history that conflicted with the statute. That strikes me as a very helpful way to deal with these debates, and I think makes originalism a little less controversial. I mean, as long as the burden is on the party trying to say that this 18th century provision or 19th century provision applies to this modern dispute, I think that's going to help us deal with some of the concerns that looking at history is just going to become another form of looking at legislative history and statutory cases where the risk is that judges are going to look for friends in the crowd, pick the friends they like, and get the place they want to get. But I do think the early state court judges and the way they handle judicial review is a really nice lesson for dealing with that problem. Next point. So I did this in 2018, and no surprise, the second book talks a little bit about the idea of how state courts have an independent duty to look at the meaning of their state constitutions. And this is trying to deal with this problem, which I'll use the term lockstepping just to simplify things. The idea behind lockstepping is that state courts take a provision like due process, reasonable search and seizure guarantee, and presume that the meaning of the Montana guarantee mimics locksteps with the meaning of the federal guarantee. And I won't go through all the reasons why that's silly, but I do want to emphasize a couple. First of all, it's an odd approach to interpreting an independent state constitution, the Montana Constitution. It's an odd thing for state court judges to do because these guarantees actually all originated in state constitutions. They didn't originate in the 1789 federal constitution. They didn't originate in the 1791 Bill of Rights. They were all cut and pasted from the early state constitutions between 1776 and 1786. So it's very strange to think that what the federal guarantee means should somehow mean what the earlier state guarantee should mean. That's thing one. Thing two is some state courts, and I don't think the Montana Circuit Court has made this mistake, but some state courts do the very odd thing, which is say, we follow the federal interpretation now and in future. In other words, we're just lockstepping into the future. Well, that I consider quite bizarre. No one takes a trip without knowing the destination, and it seems awfully strange for a state court to follow the U.S. Supreme Court wherever it happens to go, increasing rights protection, or for that matter, decreasing them. So that's a funny one for me. I want to emphasize a couple other things that I think help show that state courts really ought to take quite seriously their independent duty to construe their own constitution. It turns out a lot of these guarantees, in fact, the ones we fight the most intensely about, are in very general language. And it's really odd to think that the word unreasonable, cruel, or unusual, Montana has a privacy guarantee, free speech, free exercise guarantees. Those are written at a fairly high level of generality. You would think they would me is an area where state courts not only can, but probably should be customizing the meaning of these general words to account for local circumstances in Montana, local history, culture, politics, you name it. And it's actually kind of a nice feature of federalism as opposed to a problem with federalism. Another point that I'm very sensitive to as a federal judge, much as I love the federal courts, I think federal judges do the best they can in construing these terms. I can't say we always get it right. In fact, I think there's some areas of federal constitutional law that, if they're not bankrupt, they're approaching bankruptcy. Tiers of review comes to mind. It made a little bit of sense. We had strict scrutiny and rational basis review. There were just two to pick from, kind of one under one and lost under the other. Then we have intermediate scrutiny. Then we have rational basis plus, at that point we're up to four. In my understanding, I think there's a professor from Temple who says we have now 7 tiers of review. Clearly a growth industry. I suppose in one sense you could say it's almost biblical. Day one, God gave us rational basis. And so forth. But it does seem a little odd to think that we can keep coming up with new ways to slice this. At all events, the key point for me is whether you're a state lawyer or a state judge, and you've got an equal protection case or a potential tiers of review problem, how could anyone reflexively say that's the answer to dealing with these cases? It seems to me time for state judges to be remembering some of the history. The state judges innovated the idea of class legislation as a way of thinking about classifications, which are usually at the core of equal protection cases. But at all, the real point is why would you lockstep with a doctrine that's very elusive and arguably not working at all? I'm sometimes asked at this point, well, gee, Jeff, maybe one reason state court judges presume federal law tells you the meaning of a similar state guarantee is that many state court judges are elected either in partisan or nonpartisan elections, and that, of course, is true in Montana. I find that a puzzling response. One would have thought that elections would liberate local state court judges from the pull of Washington, D.C. Imagine if I ran for the Montana Supreme Court and I were asked the question, what do I do with the very difficult questions of state constitutional law? And what if my answer was, well, gee, if it gets really difficult, I just ask myself what the people in D.C. think is the right answer in the meaning of due process. I can't imagine that as a winning approach to getting elected to the Montana Supreme Court, or frankly any court in Montana. So one would think that local elections would lead to local pride. Local pride would lead to intense independence when it comes to the meaning of state constitutions. Now, one way in which independent construction of state constitutions applies to, this is what is national and what is local, the key theme, is that there's really an important dialogue going on between the state and federal courts. And there's also a really significant practical component to it. Sometimes the U.S. Supreme Court innovates in a way that adds meaning, adds guarantees to language in a constitutional provision that people don't care for in a state, say Montana, and other times they can subtract, dilute the meaning of a federal guarantee. And let's just talk about those 2 points, because in both settings, they leave considerable room for state courts and state lawyers to respond. Now, when the U.S. Supreme Court subtracts, when they seem to dilute, under-enforce a federal guarantee, say free speech, free exercise, whatever it might be, search and seizure guarantee, maybe that's a very good example. The subtraction problem leaves a gap, right? The federal courts and the U.S. Constitution do not apply to this particular conflict between individual and government. In a subtraction situation, that leaves a gap that can be filled by of this because every state in the country either has that exact phrase, unreasonable search and seizure, or similar privacy-related guarantees, but there's some form of protection throughout the country, and certainly one in Montana. So when the federal court subtracts or under-enforces a national guarantee, this leaves this really significant role for the state courts to fill the gap for the second shot of invoking the state constitution in state court. You know, I would just pause there just for 1 second before I go to the petition problem. One of the amusing things to me about law schools and about American constitutional law is this obsession we have with the federal courts and the federal constitution. And I say obsession because it really seems that way when you think about the number of cases that run through the state courts versus the federal courts in a given year. The last year for which I have rough numbers, the federal courts had about 400,000 criminal and civil cases in the year. The counterpart number for the state court system is 40 to 50 million. 400,000 versus 40 to 50 million. And all we want to talk about is the 400,000. Boy, that seems strange. And I mention the 40 to 50 million because virtually every one of those cases, the extent it involves the direct problem, gives you the two-shot opportunity, the opportunity both to live in the federal constitution and the state constitution. So what about a different problem in the U.S. Supreme Court? The problem where they seem to be adding a protection that either isn't there, it's just a power grab, they're adding a gloss to a guarantee that really isn't supportable, or it is contestable, and it just happens to be the way the court at a given time goes with it. But the key point is they're adding something. Now, the traditional reaction to that, this is quite important, is to assume there's nothing state courts and state lawyers can do about it. The supremacy clause of the U.S. Constitution requires state courts to honor interpretations of the federal Constitution by the U.S. Supreme Court, mention state judges by name. There's not a lot more they can do about it. And that's true in one sense. And I'm going to use a case to illustrate this. Citizens United, it's a case in Montana, as a general matter, did not seem to care for. So Citizens United is decided about 2010, and it construes the free speech guarantee of the federal First Amendment to limit the capacity of state legislatures to restrict fundraising and donations to political candidates or political parties. And, you know, it's a close decision. It's a controversial decision. If one were to generalize, I suspect it's true that most progressives in the country would put Citizens United at the top or near the top of their list of U.S. Supreme Court cases they'd like to see overruled. One part of the theory being, free speech guarantee covers speech and not money. The other more practical point that money in politics has not been great for political discourse, and so forth. I can illustrate this problem by a case that happened the year after Citizens United. Within a year of Citizens United, the state of Montana still had a law that placed limits on corporate contributions to political candidates and parties. It was challenged, largely, of course, on federal free speech grounds, because you had Citizens United there. And the Montana Supreme Court did something really interesting, quite understandable given Montana's history. And I want to suggest a slightly different approach that could have been used in the case. And so as long ago, so I suspect there are many members of that court still on the court. And I would also point out, I don't think this is really the way the case was argued. But I'm trying to illustrate what state courts and citizens can do with cases they don't care for at the U.S. Supreme Court that may have a relationship to a state guarantee. So a year after Citizens United, this case proceeds to the Montana Supreme Court. The Montana Supreme Court writes an opinion that says, well, whatever Citizens United means is a matter of federal constitutional law throughout the rest of the country. It's just very difficult to grasp the idea that would limit the Montana legislature for placing caps and other regulations on corporate contributions to political parties. And they pointed out in the era copper companies, which generate a lot of wealth, number one. But number two, and more to the point, allowed a lot of people to have a lot of influence over state legislators, state courts, state governors. And that was not perceived as a healthy chapter in Montana history as a matter of governance. And the Montana Supreme Court, right, pointed to that and said, how could it be that given our history, we have to let this kind of thing continue and can't acknowledge our history and try to prevent it from happening again. Now, the decision relied entirely on the federal free speech clause, and what you might think would happen did happen. The U.S. Supreme Court summarily reversed the Montana Supreme Court, saying, listen, Citizens United is on the books, and as long as it's on the books, you got to follow it. The four dissenters were the same dissenters from Citizens United that said Citizens United ought to overrule. How might that decision have been argued differently? How might it have been written differently? Well, I could have imagined a decision that said this. This is a challenge on free speech grounds to some corporate contribution limits. In Montana, there are two free speech clauses that potentially apply. One under the Montana Constitution, our Bill of Rights, Declaration of Rights, and one under the federal Constitution. We'll start with the local one, which is usually the best place to start. The Montana Supreme Court could have written exactly the same opinion about their history, explained that given that history, it's inconceivable that the Montana Free Speech Guarantee would place a limit on this kind of corporate contribution to political campaigns, and end with the punchline that in Montana, the Free Speech Clause protects speech and not money. New heading, federal claim, one sentence. So long as Citizens United is good law, correct, we hope not for long, close correct, comma, we must follow it under the Supremacy Clause, and therefore we invalidate this corporate contribution limit, period. Now some of you, the alert audience, are saying, Jeff, let me get to that too. The law was still invalidated. Montanans didn't get what they wanted. And that's all fair enough. But what it points out is something that to me matters a great deal. And that's the dialogue between state courts and federal courts about the meaning of these general guarantees and what's the right way to think about reform and helping get these decisions right as a matter of pragmatism, constitutionalism, or originalism. I don't care what. Had the Montana Supreme Court written the opinion I just mentioned, I do not think it's that bold a prediction to think that a handful, if not 15 to 20 other state courts, like mine, would have said similar things about their free speech clause and their disagreement with the federal interpretation of Citizens United. That's very healthy in a federal system. That lays the groundwork for an overruling of Citizens United for those who think that's a good idea. And it's a groundwork that doesn't turn on which justices are on the U.S. Supreme Court. It's a groundwork that turns on fundamental disagreement either with history or other grounds, based on history or other grounds, for why free speech does not cover monetary limits and contributions. So the key thing I'm saying is whether the U.S. Supreme Court is adding rights, there's a role for state courts to say, you don't think that's the right interpretation, come back, lower the federal standard. And when there's a subtraction problem, they're not honoring the guarantee, or they're not enforcing it in a way that people think is important. U.S. Supreme Court leaves a gap for state courts to fill with the second shot of the state constitution. The next point about lockstep and the proclivity to, I think, pay too much attention to the federal language, the federal debates about the meaning of the federal constitution, is a really fun chapter of Montana history, and it's a part of American history. I gotta say, before doing this book, I knew very little about it. And that's the territorial phase of virtually every state in the country that gets statehood after the initial 13 colonies become states. So Montana's territorial chapter is 1864 to 1889, so it's a pretty long period. And what's really interesting about, when I talk about this actually Montana experience in the book, what's really interesting about that experience in Montana and all the other states, Midwestern, Southwestern, Western, is status meant you were a federal enclave. If you like, you can think of it as colonies vis-a-vis the crown. But all power came from D.C. There were governors of the territories, but they were governors appointed by U.S. presidents. There were territorial Supreme Courts, but their members were appointed by U.S. presidents, and the same was true of the early legislatures. Now, once you got enough people in the state, you could get your own legislature and elect them locally, but still federal law in large and ultimate control. Now, what led people in the territories to see statehood was precisely the opportunity to write their own laws, write their own constitutions, elect their own governors, and choose their own state Supreme Court judges or state judges in general. And so obviously very localized. And the thing that grated on people was the carpetbagging concept of people with close connections to a president or a political party in the East Coast, getting these appointments and then coming to be governor or state Supreme Court justices knowing very little about the territory. There's one story in the book which kind of illustrates it, where a trial is being held or is about to be held. You've got this judge who's just arrived in Montana from the East Coast, presumably educated at the elite East Coast schools, and at the beginning of the trial he notices that one of the jurors does not have a jacket on, like a jacket, coat, tie, and he says to the bailiff, this is an important proceeding, everybody should be formally dressed, and please ask the juror to go home and put on more appropriate suit, tie, or at least a jacket. So the bailiff does this, the juror leaves the courtroom, 15 minutes go by, half hour goes by, the judge comes back and says to the bailiff, when's this guy going to get back? He says, well, sir, he lives about 15 miles away, and he just got in his horse and he'll get back as soon as he can. So this was obviously a very clueless Easterner presiding over a Mountain West trial. And it kind of captures the problem that Montanans in the territory wanted Montanans to be their judges, their governors, and their legislators. That kind of backdrop makes a state court judge or state lawyer who looks only at federal common law interpreting the Montana Constitution look very much like, I dare say, a territorial judge or a territorial lawyer. So next point, this one, the U.S. Supreme Court is so on the mind of folks after such a remarkable term. It's at so many levels, and it's just impacting us in lots of ways, whether it's because we're having local debates about issues that could also be national, or we're doing national debates about things that some of us think should be local. But I did want to make one observation about the U.S. Supreme Court that I think it's going to change one way or another. And the change is likely to increase the salience of state courts and state government in general. There's a three-legged stool that describes the U.S. Supreme Court over the last 75 years when it comes to its influence on American government. And from my perspective, it seems very hard to imagine all components of this three-legged stool being sustainable for the next 75 years. So leg one is the reality that the U.S. Supreme Court for the last 75 years has been very engaged in judicial review, and I don't think it's an exaggeration to say engaged in judicial review more than any court in Western history, if not world history. And it's really hard to think of a country that has a court system that makes so many significant decisions in their society. So that's thing one. The second leg of the stool is the reality that they're interpreting a Constitution that is the hardest to correct. I don't know if I can say the hardest to correct in world history, but you're not John Diamond later today who's truly the expert on this, but I'm not aware of countries that require a 75% threshold before you can amend a constitution. Australia might have something along those lines, but I doubt that very much that there's ever been a country where the court system engages in judicial review as much as ours does, and then is construing a document that can't be correct. And the reality in this country is that the Article 5 requirement that you must get 3/4 of the states to ratify an amendment makes the possibility of correcting a U.S. Supreme Court decision virtually impossible if it concerns anything remotely controversial, because it's going to be so hard to get 3/4 of the states. The third leg of the stool is that the judges on the court have life tenure. So there's no way to change the composition of the court, say, by the arbitrariness of who's president when, who controls the Senate when, who dies when, who decides to leave when. That combination doesn't strike me as sustainable for the next 75 years. Something has to give. I suspect we have a court right now that is more interested in shrinking its footprint on American society. We'll see if that proves true. Certainly Dobbs is a case where they do that, although people might say Bruin's a case where they don't do that. Although I would say Bruin, right to bear arms case, does leave considerable room for local experimentation. But my real point is it's just hard to imagine that combination of three features of our federal court system remaining in place for the next 75 years. Well, that presents the really interesting contrast with our state courts, where I would say, as a general rule, none of those three things are true, or not one of them is true. You don't have any one state court engaging to just review that muscular way for all of this period of time. You certainly have state Supreme Courts in times in the past and currently that engage in muscular interpretation. But I'm not sure anything quite as consistently. But the key next point is that all of the state constitutions are much easier to amend. New Hampshire, I think, is at 2/3. That's the hardest. Almost all of them are 51%. I think that includes Montana. 18 of them have the initiative where you can have direct democracy, and the people themselves can just bypass the legislature, the governor, just directly amend the Constitution with 51% threshold if it's put on the ballot. So you have a situation where the state courts, even when they engage in judicial review, if they're getting ahead of people have a way of responding because state constitutions are much easier to amend. And then the third feature is that every state but Rhode Island has some kind of election or age cap. Rhode Island does have life tenure just like the federal system, but everyone else either has age limits, 70, 75, most, 90% of state court judges must face elections at some point. That contrast between the federal system and the state system strikes me as presenting a very useful opportunity. And the way I see it is that what probably has not been healthy for the last 75 years is this tendency to do a top-down race to D.C. to nationalize individual rights in particular, as opposed to doing the ground-up of the state courts to be the initial innovators, experimenters, chief, first responders, you pick your metaphor, and then from the ground up develop these new ideas, and then sometimes nationalize and sometimes not nationalize. That's going to be a choice ultimately whether the new idea works, whether it doesn't work, whether it's worthy of nationalization, or maybe it's one of those areas, take gun control. Maybe gun control is a little different in Montana and Wyoming than it does in New York City, and federalism would suggest that kind of regional disparity is not that big a problem. I'm going to do one last point and then take questions and just be mindful of time here. But it's one other area where there's room for interaction between the federal and state systems. So substantive due process at the federal level, when you look back to the role of the federal courts and their footprint in American society, one big source of that is the use of substantive due process at two levels. One, of course, is the incorporation of almost all the Bill of Rights, making them applicable to states. That was a form of substantive due process. Less controversial because they're incorporated in enumerated rights. More controversial is the use of substantive due process to identify new rights that aren't enumerated. And, right to privacy, abortion, abortion, arguably marriage, although marriage you could say is for protection. But in all events, the key point is that's been a controversial area of federal constitutional law, and the question is whether there's a role for the states here if we're going to preserve substantive due process, a way to use the states, use state courts in developing. And I'll try to illustrate the point by looking at three cases that show kind of the transformation of substantive due process in federal common law. One is in 1949, one's in 1961, and one's in 1973. 1949 is the Wolf case, and that's where the U.S. Supreme Court incorporates for the first time the Fourth Amendment, the search and seizure guarantee in the Fourth Amendment. And the court is reluctant to do it because substantive due process is textually a little unusual. Justice Frankfurt, who's no fan of substantive due process or for that matter incorporation, writes the opinion for the court, if I remember correctly, a unanimous court. And in Wolf, the key move is to point out that every state in the country, at least that's in 1949, had some form of search and seizure guarantee in the state constitution. So for Frankfurter in the court, that's a pretty good indicator that this is not a power grab, that there's some legitimacy in saying this is truly a national norm that we can now nationalize through substantive due process and incorporation. So that's 1949 in Wolf. Go forward 12 years in Mapp, and Mapp is the next move in the search and seizure story when they adopt the exclusionary rule and nationalize it for the whole country. Now what's interesting about that is in 12 years' time, they've become comfortable nationalizing a right where by 1961 just half the states had an exclusionary rule. So the search and seizure guarantees don't mention exclusion by name. It really had a kind of a common law development. And by 1961, half the states had an exclusionary rule. And for the court in that, in 1961, that sufficed to incorporate the exclusionary rule and make it national, make it apply to the whole country, not have to be a local versus, well, a local decision. Fast forward 12 more years to go, and do your best if you can to just ignore that it involves abortion, which generates such strong reactions. I want to use Roe to just make a different point. Here they are 12 years later. They're now nationalizing the right to abortion, not because it's mentioned in the Bill of Rights. This, of course, is an unenumerated right growing out of Griswold, the right to privacy. But the key point is that by 1973, no state constitution mentioned the right to abortion. In truth, that's not true today. There are several states that put it on their ballot for this election cycle. I suspect several will enact something. But the word abortion, when it comes to protecting the right to abortion or pro-choice, didn't exist. Now, several state constitutions, Montana included, has a right to privacy, and that arguably could create abortion rights protections. But the key point I'm making is just think of it as rights A, B, and C and just forget what they are. When right A is created, the court requires every state in the country to recognize it. When right B is created, they require half of the states to protect it. And when right C is created, none of the state constitutions protect it. If you're asking me going forward what this is going to look like, you're going to go back to the Wolf era. And we're either going to have a world in which the court doesn't do substantive due process with respect to unenumerated rights, or when they do it, they're going to insist on more evidence from the states that there's really a guarantee here that is worthy of nationalization, not as proved by what the justices on the court think is important, but more as what's proved objectively by what states have guaranteed it to state court decisions, or by putting language directly in the state constitution. And I think that will really, well, it's just going to change the dynamic, if you ask me. And as we've seen since the end of the last term, there's really a spotlight on the states right now, whether it's state legislation, state constitutional amendments, or state court decisions, to particularly fill gaps. This is the subtraction problem, to fill gaps left by the U.S. Supreme Court. And I hope in some cases the opportunity, when there are addition problems, to show that maybe those U.S. Supreme Court decisions aren't right, as indicated by thoughtful state Supreme Court decisions indicating that maybe that language doesn't cover this or that problem. Well, I could go on for quite a bit more, sad to say, but I'd love at this point to see if I've provoked anybody, and if there's some questions, it's always nice to respond to questions. So I'm happy to do that at this point. I don't know if I should be talking to the dean, the editor, or who it is. But
yeah, so we have you here, Judge. So we'll here's how we'll do this. Judge, can you hear us okay?
Great.
Cool, so I'm going to walk around with the mic, and if anybody has a question, I'll give you the mic, and Eric will just repeat the question into the Zoom so everyone on Zoom can hear it, and so that you can hear it, Judge, and I think we should have time for a couple here. We'll start with Justice Nelson.
Judge Sutton, thank you for your remarks. They were quite interesting, especially about Montana. I have a question. There's a case on the next term of the U.S. Supreme Court, Harper versus Moore, I believe, and it involves the independent state legislature theory. It could be theoretically at least a very narrow decision, but I know that a number of state legislatures, I think ours included, are just frothing at the mouth, thinking that, boy, this is going to be the decision that ultimately says that the legislature can make decisions about state law, notwithstanding anything in the state constitution to the contrary. And I just kind of wonder about what your thoughts are on that.
Yeah, good for you. It's a great question and a crazy hard question, and one, this is why I'm a middle management judge. It's never fun to do this kind of stuff. But it really, really interests me, and just to give a little context for some of the people in the audience who might not know the case. So this is a case from North Carolina, and if I'm remembering correctly, it's a case where the legislature is drawn from districts, and the state court is interpreting its state constitution's fair and free elections clause, and validated the state legislative election lines, and had a big role in ultimately drawing new lines. And what's really interesting about the case, I think difficult, is the U.S. Constitution refers to state legislatures, so the keyword's legislature, and their responsibility to draw these lines, although it also gives a role to Congress. That's quite important. And here we're talking about lines. I'm pretty sure the lines that issue in that case are lines for the congressional districts, and I think in North Carolina you had to have new lines because I think they had a seat. I think North Carolina's a gross state. So after the census, you had to do something. You couldn't just rest on, you couldn't use the prior one. You had to change them because they had a new representative in Congress. So you had to come up with new seats, and you get these stalemates. And what do you do if the state court says the legislative districts have a problem in the state constitution, and the legislature either won't respond or responds only with lines that don't satisfy the state court? What do you do? One argument is that the literal meaning of the federal constitution refers to legislature, and it means state courts have zero role to play when it comes to interpreting and accepting challenges to these state legislative election rules. That seems to me a little hard. It's possible. You said some state legislatures, I don't use the word frothing, but it was close to that. Excited about the idea of the state court with a no role. What seems odd to me about that is it's so easy to imagine a state legislative election rule which had an ambiguity, and I think we would all assume state courts have a role to play in terms of figuring out what the statute means. Like, that's a background principle that surely the framers of the federal Constitution would have thought was true. And of course, the other background principle, as you know from my talk about judicial review, is they knew judicial review existed. Hamilton mentions it in Federal 78, and of course the state court judges have been doing it. And so a background principle would be whatever a state legislature did, the assumption would be that it would comply with the state constitution. And, you know, that seems strange to imagine they wouldn't accept that as part of a background principle. Therefore, it would be if the state redistricting or other voting rules violate the state constitution, you think the state courts would have a right to say it's not enforceable. So that's the side of the case that I suppose is good for North Carolina. I do wonder if there's some limit to this. I mean, could a state court really pull a rabbit out of a hat? And I suspect at a minimum that the U.S. Supreme Court is going to wonder about that, but it's a very difficult problem to enforce and figure out exactly when they're pulling rabbits out of hats. You know, state court, pretty confident it would bother the U.S. Supreme Court in saying, and the state court said, we now interpret separation of powers in North Carolina to mean there were just two branches, the courts and the governor, and we, the courts, are going to take over the legislative authority. I wonder about that word. Maybe. But I don't know, this is odd to me. I'll just say one other background point, as you can tell, I'm just generalizing every which way. No clear answer on anything. But there's just one other background principle, which is interesting, a background case. In 2019, that's just 3 years ago, in Show, very close case, the U.S. Supreme Court said in this exact area, political, extreme partisan gerrymandering, it was a political question. And, you know, the court refused to use the 14th Amendment to limit some pretty extreme partisan gerrymanders coming out of, frankly, Maryland, the other one is North Carolina. So it's very funny to have them say, we think it's a political question, no discernible standard. And, okay, maybe they say the discernible standard is only the legislature, but, wow, no role for the state courts. That seems odd to me. The only other thing I'll say about the super interesting question is the court a couple of years ago had the question of whether a redistricting commission created by state initiative, not for the legislature, but by the initiative process, which of course Montana has, could that violate the independent state legislature doctrine? And on a 5-4 decision, the court said no, it was 5-4, and Chief Justice Roberts wrote the dissent, Justice Ginsburg wrote the majority. So that, I guess you have to say that's another working point. Well, I would just add one other feature of that case, which is a feature of the case that makes it possible to have a very narrow ruling. I think in the North Carolina law itself, they explained the role courts could have in these kinds of problems. So if the legislature permits the court to have a role, that seems to me okay. Vice versa, people of the state can do what Ohio did, which is a constitutional amendment that precluded the Ohio Supreme Court from redrawing district lines every 10 years. That's part of their commission approach. The court can do all kinds of things, they just can't redraw the new lines. And I suppose anyone that's really nervous about the role of courts here can just use the Ohio constitutional amendment route. So feel free to follow up. I know I raised more questions than I answered. That's a classic, forgive me. But do you want to follow up?
Well, Judge, if you got enough time, I think we have one more question over here. It might be a little different, and then I think we might have to wrap this.
Great.
Thank you for the thoughtful discussion, Judge. I'm an attorney here in Montana, and I guess I wanted to raise maybe some different considerations on the originalism. To me, it seems like there's a distinction to be drawn between a judge informing themselves as to the historical record and originalism proper, which is a modern judicial heuristic, which was proposed by Robert Bork in his 1971 law review article. And it was a reaction to Griswold. I mean, he didn't like the decision there. And I guess the only thing I would just point out is I do think there are some inherent dangers to originalism which we should be wary of. And the Dobbs decision I think highlights one, because when Justice Alito cites a raft of decisions from the 13th and 17th centuries, those were during an era where women were considered chattel. And so the idea that a woman could have sexual autonomy just simply didn't exist in that era. And so now we've had, 60 plus years, 50 years, where this idea is a real idea in society. And so for 5 judges to decide that this idea doesn't exist in that way is extremely disruptive. And I think we just need to be mindful of that because, Roe could have been decided differently, right? I mean, it didn't have to be decided that way, but yet it was. And so the manner in which the court pulled the rug out from under women across the country means that as a direct result of that decision, some women have already suffered, and some will actually potentially die. And I think sometimes Supreme Court justices need to realize that those decisions have real world impacts. And so I guess I would just say that I don't know what the question is, but more of just like a reaction. I mean, you did say, does this provoke anybody? And I was like, yeah, I'm a little bit provoked. And so I guess in a weird way, I suppose I would just suggest that. Oh, sorry.
100%, and let me give you a couple thoughts, and then feel free to respond to what I'm saying. I started by saying what's the big American challenge is what's national, what's local. And another way of thinking about that problem, and it's very sad to me that originalism has gotten criticized because I really think it's mainly quite conventional. You have written constitutions, so you have words have fixed meaning, the words normally don't grow, unless you use a word like unreasonable or unusual, which might have a growth concept embedded in it. But what I would say is the real point, and this goes back to whether it's sustainable to make national decisions the way we have the last 75 years for the next 75 years, is how does a country deal with change? Like, that's the real point. And, at the outset, no one thought of, quote, living constitutionalism because everything was fresh. There was nothing to think about. They assumed that the federal constitution would be amended regularly. The state constitutions were amended regularly. This is very exciting. It's a great point of the democracy principle. The state constitutions just kind of show you what Americans want in each of these eras. And it's so easy to adjust their constitutions because they have this 51 to 2/3 threshold, which is so much easier to meet. Even though the federal threshold is 3/4, we used to have a culture in this country of amending the Constitution. I mean, 19th Amendment is a great example, and you could say, hey, Jeff, that was 75 years. That took a long time to put that in the Constitution. It seems outrageous that there's so many elections where women weren't voting. But, the one thing about that process is, well, a couple things about that process. One, it locked it in. I mean, after 75 years, no one's debating that. But the second thing is political parties back then realized that there were benefits to ratification of federal constitutional amendments. Political benefits. Like, they decided we're on the right side of this issue, so take abortion. You can decide you are on the right side of this issue. You want a 50-state fight on this. You want to go state by state saying, here's what the federal constitution should say. And we're not going to rely on 5 out of 9 because we know from the Lochner era, the 5 out of 9 just as easily protect, property rights or free exercise rights, something maybe you're not, one is not quite as excited about. But when you go the federal constitutional amendment route, you stabilize it, and I've often thought there's a lot of political advantages to doing it that way, and that's actually a benefit. I think the problem, and what's challenging about Dobbs, and I'm not do anything other than take it seriously. I don't think there's a great defense of the underlying relevant usage. I think the real point is this problem that had been there for 49 years. The change in the composition of the court seemed to be, as much as anything, the reason for its being overruled. And that seems strange to think of that in the rule of law. But this is the problem with having the federal Supreme Court have this kind of a rule. I mean, no one was complaining about overruled decisions in the 1960s if they were progressives. There was none of that. There was no, wringing your hands over stare decisis, worrying about the legitimacy of the court from a progressive perspective. So it just goes back to the Ox's gourd problem and our instinct to nationalize when we really like it and be comfortable with localization when it's not quite as important to us. I mean, I appreciate what you're saying, but I'll just use one last example to illustrate the point, because the stakes of this one are even higher than they are in Dobbs. You make the point of women dying. That's very stark, but I'm not going to deny that possibility. We need to rethink how we do change, and a great illustration of this is capital punishment. So I think it is a matter of policy against capital punishment. But I would say the folks that believe in abolition using national courts to end capital punishment have done more to execute people than avoid executions. How could I say such a stark thing? Well, in the early 70s, when you get Furman versus Georgia, the U.S. Supreme Court puts a pause on the 8th Amendment and says no enforcement of capital punishment throughout the country. It leads to a very strong backlash. People forget that at that point, states actually were not enforcing the death penalty very much. I think that's why the U.S. Supreme Court thought it was possible they could nationalize opposition to it, or nationalize abolition. But that isn't what happened. The states, for whatever reason, I was a teenager, more worried about sports than anything else, etc. But what I do know is the statistics prove that the states responded very aggressively and wanted to enforce capital punishment in opposition to this national decision saying that they couldn't. Guess what's been happening lately? And what I think has had a lot to do with having fewer executions in this country. The approach of doing it local and from the ground up, including in states like Texas. And there's a new book out. I can't remember the name. It's reviewed in the New York Times. It's written by someone who works for the Marshall Project. His point is to end capital punishment. And he's explaining why grassroots, localism, state-by-state approaches have been so much more effective than the top-down nationalization approach. Now, I can't say that that analogy works for abortion, and in 5 years we'll see that things worked out well. Who knows? No one knows the future. But I will say it's a really interesting example of how localism might secure the right. And it might be that, people are really happy to see Roe and Casey gone if they really embrace the decision. But lots of people thought it was a very unstable decision and were very worried about it, as proved by the fact that it's so central to our Senate and presidential elections. The question is not just getting the right you want, it's getting it stabilized and not having to defend it over and over. And who knows what's going to happen after Dobbs. But I do not think it's clear which way the story is going to break, and I don't think it's clear whether women are going to have more or less protection by the end of it. I'd be careful about assuming that. I wouldn't assume in either direction.
Judge, I think that's going to be our time. I really appreciate you. I wish we could continue this Q&A, but we have a whole day that we are getting behind on. So we appreciate, Montana Law Review appreciates so much you joining us, and this was an incredible talk and fantastic. And so if we can get the judge around